Good morning. This is the COGCC Wednesday, July 27th, 2022 regular meeting. First item on the agenda today is a roll call of the commissioners.
Thank you, Mr. Chair. Commissioner Ackerman.
Here.
Commissioner Bowe. Commissioner Cross.
Present.
Commissioner McGowan.
Here.
Commissioner Mesner.
Here.
Commissioner Robbins. Mr. Chair, you have 5 out of 7 commissioners present.
Thank you. Next up, we have commissioner comments. Does any commissioner have comments they'd like to share at this point? Commissioner McGowan?
Sorry, thanks. I was wondering if staff would be willing, and I don't know if all the commissioners saw this presentation. It was, I think, 2 operator training meetings ago. It was an update on leaks, number of leaks and what causes the leaks. And the number 1 cause, once again, is corrosion. And I was wondering if the staff wouldn't mind giving that presentation at a commission meeting or one of our planning meetings on a Friday, so we could talk about that a little bit. And I continue to kind of mull over whether or not we have things in our rules to appropriately address preventive measures for corrosion on equipment. And I guess it was a big picture presentation about why we have leaks, but no information about, is it mostly aged equipment? Are there specific operators that are seeing more leaks than others? And I think I would be curious or interested in having that conversation with our staff if the other commissioners are.
Seems like a good idea to me. Is that something that we could schedule?
Certainly, we can definitely have staff present that to the commission at an upcoming hearing.
Any other commissioners with comments? All right, seeing none, we'll move on to the consent agenda. Do any commissioners have any questions on items on the consent agenda? Seeing none, I'd entertain a motion.
I move to approve the consent
Move
agenda.
adoption. Second.
All right, we've got a motion and a second. Is there any further discussion? All those in favor signify by saying aye.
Aye.
Any opposed? That motion carries. I will note that there was no written comment, written public comment, and no one signed up for verbal public comment today. So we're going to move right into our next docketed item, which is docket number 210600095, which is the Gaffney Oil and Gas Development Plan, with the applicant being Verdad Resources. So if we can get folks up on the panel with Verdad Resources, we can get started with this. Mr. Bijala, are you leading the charge here?
I am, and I'm sorry I was muted there.
Okay.
Thank you. Good morning, Mr. Chair, and good morning, commissioners. My name is Joe Pershala with the law firm Wellborn, Sullivan, Tully, and I'm appearing here on behalf of the applicant, Verdad Resources. Also with me today are Heather Mitchell, our regulatory manager, Mike Cognetti, director of EHS&R, Neil Hudson, production manager, and Lamar Sapi, the land supervisor. Verdad is a registered operator in good standing with the commission and has met all financial assurances required by the state of Colorado. In this oil and gas development plan application, Verdad is requesting the commission approve an OGDP covering 960 acres, and that is covering all of section 20, the north half of section 29, and that's in township 9 North, range 59 West in Weld County. The OGDP includes requests to amend an existing oil and gas location, that's the Gaffney 2-29-8-61, its location ID 435303, and it would be renamed as the Gaffney 2920 location. It currently has one existing well on that location. Verdad is asking the commission to increase the number to a total of 8 horizontal wells on the location. So that would be 7 new horizontal wells, 1 existing horizontal well on that location. The OGDP further requests that the commission modify a 960-acre drilling and spacing unit that was established by order number 535-420, and that's originally to cover the Niobrara Formation on the lands that I previously described. And the request is to add the Fort Hays, Codell, and Carlisle formations, and also to reduce the approved number of horizontal wells from the prior 16 to 8. And again, that's 7 new horizontal wells with the 1 existing horizontal well, all to be drilled from the Gaffney 2920 location. And I think there might be a little bit of confusion on this point, and just in the director's recommendation versus what's in the application itself. The original application requested that order 535-420 be modified to add the Fort Hays, Codell, and the Carlisle formations, and also approve up to 10 horizontal wells. There was a second amended application, however, that reduced the requested well count to 8. And in the director recommendation, in the notes there, it notes that order 535-420 approved up to 16 wells in the Niobrara Formation. But as I said, Verdad is only looking to drill 7 new horizontal wells for a total of 8 in the unit. The recommendation does not note that the application also seeks to add the Fort Hays, Codell, and Carlisle formations. And then again, as I said, reduce the total number of approved wells down to 8 horizontal wells. So I just wanted to resolve any confusion that might be there. The granting of the application would only allow for a total of 8 wells within the 960-acre unit. There are no additional wells currently planned in that unit. And if there were to be additional wells, that would require future amendment of both the spacing order and that would be entered after this application. And again, the Form 2A for the Gaffney 2920 location that we're asking be approved. Finally, the application requests that the commission establish the same well location rules for the Fort Hays, Codell, and Carlisle formations as those that were previously approved for the Niobrara Formation, and that would be 300-foot unit boundary setbacks and 300-foot inner well setbacks. The Gaffney 2920 location is located in the southwest quarter of the northwest quarter of Section 29, which is within the drilling and spacing unit. With respect to Verdad's ownership in the unit, Verdad has secured more than 45% of the leasehold in the unit and is an owner with the right to drill and produce in those application lands. The location itself is on fee surface in a rural part of Weld County. It does not meet any of the Rule 304B2B criteria. I would note that while the location is in high priority habitat for pronghorn winter concentration, Verdad worked with CPW to mitigate the impacts, and on June 29th, 2021, CPW waived the alternative location analysis required for this location. A copy of that CPW waiver was submitted with the Form 2A. Nevertheless, Verdad did submit a alternative location analysis with its Form 2A, and Verdad does have a surface use agreement with the surface owner for the siting of this location. Weld County is the relevant local government, and on January 27th, 2022, it approved the location, and there are no proximate local governments within 2,000 feet. The application does not seek any variances. Verdad did give proper notice pursuant to Rules 303E and Rule 504. No petitions or interventions were received. On July 20th, 2022, the director issued her recommendation, which recommends approval of Verdad's application. The application does satisfy the Conservation Act and Commission rules, and therefore Verdad respectfully requests that the Commission adopt the director's recommendation and approve this application. And with that, I will turn it over to Ms. Mitchell, who will introduce you to Verdad and give you an overview, of the Gaffney 2920 Oil and Gas Development Plan. Thank you.
Mr. Pershaw and Ms.
Yes.
Mitchell, thank you for that initial presentation. I did go off script here a little bit, and typically we've got Jason Maxey from Weld County that gives a presentation before you. I'll leave it up to you guys if you want to finish your presentation and take commissioner questions before we hear from Mr. Maxey, or we can have Mr. Maxey give his presentation now, whichever you prefer.
Well, I think if the ordinary course is for Mr. Maxey to present first, I think that makes sense for him to go.
Okay. Apologize for the oversight there. Mr. Maxey, are you ready to share Weld County's perspective on this particular application?
Yes, good morning. Thank you, Commissioner Messner, and thank you to the rest of the commission for a few minutes, and no problem whatsoever. I was anxiously waiting, so thank you. And my comments will be probably fairly brief, as this is a very remote location that is being proposed before you today, and Weld County has already completed our permit process for the Verdad Gaffney 2920 application. Weld comments to the COGCC were submitted on May 5th, 2022, and they are reflected on the Form 2A. A pre-application meeting was held on February 8th, 2021, and that included an in-depth alternate siting discussion on the Gaffney 2920 pad. The attendees of that pre-application meeting did include oil and gas energy staff, along with other Weld County staff, Verdad staff, COGCC, and the CPW. The application was actually submitted to Weld County on November 19th of 2021, and the application ultimately included 2 alternates in their application to Weld County, all of which were thoroughly reviewed and discussed by Weld County staff and the hearing officer, and were a part of that pre-application meeting that was held earlier on in 2021. COGCC and CPW were both sent referral requests. Weld County did not receive a response from CPW, but the COGCC referral form was received on January 7th prior to our hearing, so we do appreciate that. We didn't have any public comments during the hearing for this location. We did receive 1 application for intervention through our process, and that application was granted by the hearing officer. However, it's worthwhile to note that after receiving that application for intervention, both myself and one of my staff, Jennifer Teeters, who handled this permit, had discussions with the interventionist to try to answer any questions ahead of the hearing. And due to those discussions, that application for intervention was actually withdrawn, and they did not participate in the hearing. So we were able to answer all their questions ahead of time. The hearing was held January 20th, 2021, and the final order was issued and was recorded with our county clerk and recorder. And the final order, the final notice was also legally published in the Greeley Tribune at the end of January 2022. So as our submitted comments to the 2A form with the state mention, and also as Director Murphy's recommendations reflect, Weld County does support approval of this permit. So thank you again for a few minutes to just recap the Weld County process. And if there's any questions, I'd be happy to answer them.
Thank you, Mr. Maxey. Commissioners, do you have questions about the local government process and approval? I don't see any questions. So thank you, Mr. Maxey, for being here today.
Thank you very much. I appreciate it.
Thank you. All right, Ms. Mitchell, I think we are ready.
All right, good morning. I'm going to share my screen and hope it goes smooth. Are you able to see my screen?
Yes, we are.
Great. Good morning. My name is Heather Mitchell, and I'm the regulatory manager for Verdad Resources. And I am going to talk today about our Gaffney 2920 OGDP application. Since we have some new commissioners, I just want to reintroduce Verdad. We formed in 2015, and we have 60 full-time employees located here in Denver, Fort Morgan, and also Dallas, Texas. To give you an idea of our size, we are going to be filing as an option 1 operator here in September. We operate about 299 wells. All of them are in Colorado, primarily in Weld County. We have drilled and completed about 125 of those wells, and we've been running a 1 rig program since 2020. Okay, this slide is to orient you to the location and also go through some of the ALA criteria. The red rectangle in the middle is our unit. And then we have 5 miles, 10 miles, and 15-mile circles around it. From here, you can see that we are 16 miles south of Grover, which is our nearest municipality. And we are just south of Highway 14. As far as human receptors go in this area, we aren't near any schools, high occupancy building units, disproportionately impacted communities, or outside activity areas. And our nearest residential building unit is 1.4 miles to the northeast. In addition, there aren't any sensitive water receptors such as floodplains, wetlands, Goody wells, type 3 aquifers. None of those are triggered by this application. However, we are in high priority habitat for the pronghorn winter concentration area. And you can see by this map that the yellow is the high priority habitat, and we are encompassed by that habitat, and there is no way for us to develop this unit from outside of the habitat. I think for this reason, CPW chose to waive the ALA, in addition to the fact that we're going to be reoccupying an older pad, an older and existing pad. We did do an ALA for Weld County, and so I'll just go through that briefly. This is our unit, which, as Joe mentioned, is the north half of Section 29 and all of Section 20. Our proposed location is in the south west of the unit. We also looked at a new pad, option A, in the center of the south of the unit, and also another location that is an existing operator's pad or near an existing operator's pad, another operator in the northwest of this unit. All 3 of these locations could develop the unit without a lengthy reach or any sort of problems like that. We could all be developed from each. The whole unit could be developed from those pads individually. None of them triggered any other ALA criterias, but all of them were still within the high priority habitat. Option A would be new disturbance, which would be an additional 10 acres. It's also further off the road and closer to the residential building unit. Option B is another operator's pad that would need to be expanded. And I think we believe that we're always going to choose a pad that is under all of our control. We think that's the safest way to operate. And in addition, this particular location is 5,000 feet closer to the nearest RBU, which is to the northeast. And then just kind of zooming in closer to this location, we are able to drill all 7 of the new laterals, which are 1.5 miles long from this proposed location. It's ideal for geological reach. And again, this is an existing location. It is off an existing road and near an existing gas line. We're not close to any sensitive water receptors. We have assigned SUA, and actually we do have a 2A approved for this location. It had 6.3 acres. We're asking to amend that to 10 acres. We think that 10 acres, it gives a little more room for our frac spread so that we feel like we can most safely operate within the 10-acre disturbance. In addition, this area is dedicated to a third-party midstream operator for both oil and water. Because it's in a high priority habitat for the pronghorn winter concentration area, we did complete a wildlife mitigation plan with CPW and COGCC. And some of the things that we are planning on for this location is Verdad commits to avoid the construction operations between January 1st and April 30th. So we plan to stay outside of the habitat while for the heavy operations while the antelope are there. We have committed to both direct and indirect compensatory mitigation fees. There are 2 locations within a square mile, so we qualify for the indirect fees as well. We plan to have a lay flat line for completions to reduce truck traffic during completion operations. And we plan to connect to an oil and a water line, which will reduce truck traffic and tank emissions during production operations. This pad will eventually be reclaimed with a CPW seed mix as long as it's approved by the landowner. These next two slides are just a few of our VMPs. Most of them are standard throughout all of our operations. But all of them can be found in our cumulative impacts plan and other mitigation plans that were attached to this application. I think our biggest mitigation here is that we plan to avoid the timing where the pronghorn are the sensitive timing for the pronghorn, January through April 30th. We are re-occupying an existing pad and that's connected to an existing access road. So we will be reducing further habitat fragmentation here. Also, we'll stay in compliance with both light and noise restrictions per COGCC and Weld County. And we won't have, we'll have a quiet frac fleet. We won't have permanent lighting on the location. There are no RBUs along the existing access road. And even though we are sited away from water, we do have remote shutdown capabilities. And then this next one is just more BMPs that are connected with this particular location. This pad is designed for detention per Weld County regulations. We have robust inspection protocols. We plan to connect to an oil and water line, which will reduce tank emissions and truck traffic. And we have, as part of this plan, we will be remediating 3 older wells pursuant to our preliminary offset well evaluation. So then I have, and then this last slide is just a overview of kind of the process that we've been through with this particular location. So things of note are that we did start this process fairly quickly after the rules were implemented. We had CPW involved from the very beginning. They had time to visit the site, assess the suitability of the habitat, as well as determine impact fees for this location and accept it as a location they were willing to work with us on. And work with Weld County, as Jason mentioned, through the pre-application process. We received our WOGA in January of 2022 and have been working with COGCC to get this one to the director recommendation that we got in July of just last week, actually. So that is all I have as far as presentation goes. I appreciate your time this morning as well as your review of this application. And I am here to take questions. We have some other people on the line who can also take questions. So that is all I have.
Great. Thank you, Ms. Mitchell, for that presentation. Commissioners, does anyone have questions for the applicant? Commissioner McGowan.
Thank you, Mr. Chair, and thank you for your presentation that answered some of the questions I had when I was reviewing your application. Could you clarify for me that you said you all are going to be eliminating 3 existing wells as part of offset for cumulative impact? Did I hear that correctly?
Well, they are already, those are drilled and abandoned wells for the most part, and pursuant to an offset well evaluation, we will be remediating the cement on those, I think. And I looked at those 3 locations and they actually don't have associated tanks or land with it, but they will be remediated, replugged basically.
Okay, thank you. And I think, I'm not sure I heard one of my other questions get addressed in your presentation. I'm wondering if you could talk a little bit about, I feel like there is potentially competing information in the application, which is this is a tank light facility, yet you've got 16 oil tanks here, which I think implies to me not a tank light setup and potential truck traffic emissions. And I'm just wondering if you could talk a little bit about that.
Yeah, so I think in this case, this area is dedicated to a third-party midstream operator. So we feel highly confident we'll be connecting to an oil and water line for this location. However, the third party is not under our direct control. And so there are some things that could come up, like right-of-way issues, something with their company, a number of items that are just outside of our control. So we sort of plan max case in the event something were to happen for that, although we feel highly confident that we'll be connecting to that line. Those
So
lines.
how many oil tanks would you have if you are going to be connected to that line timely?
We would need 1 oil and 3 water tanks.
Thanks. I keep bringing this up as a commissioner, like the smaller the footprint, the less opportunity for emissions from equipment on the site. The more we can show that we're trying to minimize truck traffic, I think the best. And I think I'm struggling with the submittal of worst case scenario in the application versus what we hope or think is going to actually happen and the timing of it. So if the oil line is not set up by the time you all are ready to begin drilling and completions, all of that, do you anticipate that you would go back after your hookup to the oil line and reducing the number of tanks on site, or would those remain there?
No, we would reduce the number of tanks on site.
Okay. Okay. Thank you. I appreciate your answers.
Commissioner Ackerman.
Thank you, Mr. Chair, and thank you, Ms. Mitchell, for your presentation. Appreciate that, and appreciate your company working to stay outside of the sensitive winter timing period for pronghorn. I think it's very important, given that you'll need to operate within high priority habitat. I also agree with the findings of the ALA. Thank you for completing that, and thank you for working on the existing pad near the highway. I think that's the best choice as well. I did have a question about the sound and light mitigation exemptions, and you addressed those briefly. Just as more of a statement than a question, generally the further operations take place away from other receptors, human receptors, the more sensitive the wildlife are to light and noise disturbances. And so in the application, hopefully you can clarify for me, it looks like you've requested an exemption from the noise and light mitigation plans, but you've planned for ongoing consultation with CPW to determine acceptable noise and light limits and monitoring throughout the drilling and completion. Can you talk a little bit more about what that looks like? Does that mean that as CPW raises concerns and identifies them and identifies solutions that Verdad will implement those solutions along the way?
You know, I think our primary mitigation effort here in light and noise is to not be there when they're sensitive to, like, not have the heavy operations, to commit to not being there during drilling, completion, and construction to avoid impacts to them while they're there. And then, yes, we'll be working with CPW regularly to address anything that comes up as we're moving into specifically production operations and things like that.
Thanks, I appreciate that. And just to clarify that a little further, what I heard was that you'll consult with CPW, but is the intent to implement CPW recommendations along the way?
Yes.
Okay. All right, thank you so much. And I think Commissioner McGowan largely addressed my other question. I just wanted to reiterate her concerns with, ongoing approvals of applications without collection systems in place. Do appreciate and applaud your efforts to get those in place as soon as possible. Do you have any idea, and as you mentioned, this is, some aspects of this are outside of your control, but do you have any idea what the timeline looks like for you to be able to connect to all collection systems necessary for this development?
Well, this we're planning on, I believe, moving to construct this pad this one is kind of down the line on our drill schedule. So I believe we would construct it in 2024. And then maybe, I think we would be doing it ideally ahead of, we'd have it connected at the same time as our production operations and flowback.
Thank you. I appreciate that. No further questions from me, Mr. Chair.
Commissioner Cross?
Thank you, Commissioner Messner. And thank you, Ms. Mitchell, for your presentation. I just wanted to try and clarify a couple issues with respect to the oil pipeline and both the produced and the freshwater pipelines coming in. Is it going to run along the same route that the existing gas pipeline is running?
You know, that is an answer I don't have. That would be up to our third party to get the right of way. I would assume they would stay within right of ways, but I don't know that answer.
Okay, and I'll sort of admit that your answer there sort of answered some of my additional questions. Will you be working with the same third-party pipeline company for the produced and freshwater as well as the oil pipeline as you are with the gas pipeline?
Yes.
Okay. And again, similar to the answer today, because I wanted to try and double check if you knew where you were on sort of the rights of way, because I know that's one of the things that can sometimes hold it up. And then the other question that I wanted to go to, it kind of following up on what Commissioner Ackerman talked about, and looking through some of the correspondence with CPW that was presented to the commission and as part of your application. It also talked about agreeing not just to consult with CPW, but also talking about agreeing as part of best management practices, certain things that will continue to avoid, minimize some of the noise and light impacts, including the agricultural noise. Were there additional avoidance or minimization BMPs that were discussed with CPW, or were those kind of the limit of what was discussed by CPW and agreed with everything?
Everything that's in our wildlife mitigation plan is what we discussed. I don't think that we're done discussing. I talk with Brandon on a regular basis, so we're willing to continue those discussions, but I don't think anything else was discussed.
Okay, perfect. And that's really just what I wanted to understand, if there was additional ideas out there, kind of recognizing that you are doing avoidance measures and also minimization measures, but just wasn't sure if there was kind of additional topics on the table that might be implemented in the future based on what you've been talked about already. And then I think the last thing that I just was kind of curious about, and recognize that this is probably more in CPW's jurisdiction than yours, but do you know if there's been any discussion on what kind of uses the compensatory mitigation would be for?
My understanding is it's for habitat restoration, but it's at their discretion. So I don't know what they'll be using it for, but my understanding is habitat restoration, either near this area or somewhere else that would be beneficial to the pronghorn.
Kind of putting it in the hands of the experts and letting them figure out.
That's what yes, that's how we thought about it.
Appreciate that. And honestly, I think I'd like to reiterate, I appreciate, again, the presentation and appreciate that you guys are using an existing well pad. I think that is helpful. And the recognition that this is a little bit of a unique circumstance. Obviously, I think pronghorn is one of the bigger concerns here, but kind of no matter where you are, you're going to be within it. So the fact that even working with CPW, this appears to be kind of the point of least impact on the resource. I think that's an important consideration. So I appreciate it.
Commissioner McGowan, I will also note, should commissioners have questions specifically for CPW, Mr. Moret is available if anyone would like to ask him questions specifically. But Commissioner McGowan?
Thank you, Mr. Chair. I realized that I had another question that I sent ahead of time that I'm not sure was answered. And I'm wondering if you all are open to adding a best management practice for eliminating activities where you can on high ozone days, because this is in the non-attainment area.
Yeah, we have our own internal ozone mitigation plan that we have implemented across our operations. I think in pursuant to that plan, we will postpone certain maintenance operations, fueling vehicles, minimization, but we're happy to work with idling and things like that. But we're happy to work with COGCC to get a proper BMP in place for this.
That's great. I think we have some language that has been suggested by CDPHE in the past, and if we could just piggyback onto that, that would be great, and add that to the application. Thank you.
Any other questions from commissioners? Well, thank you, Ms. Mitchell, for your presentation. I think at this point, we will move on to commissioner deliberations. Does anyone feel like starting? I mean, I can start if you want. I mean, I think that this is, I think this is a good application. I think it's in an area away from most receptors. And I appreciate the utilization of an existing pad. I think that the commitment that was presented both in the 2A, in their wildlife plans and their transportation plans and their cumulative impacts plans to not having construction activities during the sensitive timing, to commit to oil takeaway during production, to commit to water takeaway during production, and temporary lay flat lines for water, all are important aspects for minimizing and avoiding any impacts to the pronghorn in the sensitive winter habitat, and just the high priority habitat in general. I will note that because that they are in the 2A and they are committed to BMPs, that in this commissioner's mind, that is a requirement then to commit to that oil takeaway and to that water takeaway during production, as well as the timing of construction activities outside of that sensitive area. And so I appreciate that, because I think that goes a very long way to avoiding the impacts of this particular application. And so with those commitments, I find it to be a strong application. I do think that there was commitments to certain noise standards within our 400 series, including noise receptors or noise levels below the requirements for an agricultural area. I think that there was some commitments to lighting standards as well, particularly no permanent lighting on the site, which I think are also strong things. And then I believe that staff put a condition of approval on this application to have some noise mitigation measures associated with ongoing production as well, that I think will help minimize the noise impacts to the sensitive receptors, which in this area is the pronghorn and other wildlife in the high priority habitat. So I also appreciate the operator's willingness to continue to have ongoing conversations with CPW regarding any unforeseen impacts from operations and being willing to address those as they move forward. So those are my initial thoughts on this application. Commissioner McGowan.
Thank you, Mr. Chair. I agree with everything that's been said. I do continue to have concerns when we get applications where there is a commitment to hook up to pipeline, but not a timeline associated with it, and an attempt to kind of upfront figure out how we minimize and avoid. And to me, this feels similar to the conversation we had last week with a different operator of asking for a time commitment to get connected to pipeline, so that it's not left open-ended. And so I don't know if the operator has thoughts about this. I appreciate everything that's put forward, and I know that you're working with midstream, but I don't want it to be just left open-ended that we will be trucking oil. And I'm wondering if there's a timeline we get, or a time frame within which we could add to this.
Well, Commissioner McGowan, and if the operator would like to respond to this is fine, but I read that application and the BMPs associated with the 2A and the other plans associated, that they will be committed. They will have oil takeaway and they will have water takeaway prior to production. I don't think that the language that they presented offered anything short of that. in those BMPs, and those BMPs are enforceable. So
Great. I would love clarification for that. Then I guess I'm asking why they need the 16 tanks if they're committing to hooking up to the pipeline. Why do we need the 16 oil tanks before production?
This is just to reiterate that our high confidence that we're going to have those things. I believe that we will be getting the oil and the water line. We have a very cooperative third party. We're highly confident it's going to happen, and that will absolutely be reducing the number of tanks for those needed for upset conditions. But we're basically planning for things that could happen outside of our control, and it's just a max case, which we have a history of having more permits, more tanks on the permit, and showing far less tanks actually on the build. And it's just a way to cover our bases in the event that something unforeseen happens with something that's outside of our control. And I don't know how to assure you, aside from that we have a working relationship with a third party midstream who is dedicated to this area for this operation.
Commissioners, other thoughts? Commissioner Ackerman?
Thank you, Mr. Chair. And this comment is related to this application, but it's a bit larger than this application as well. And there's a stipulation included in this application that allows for potential for drilling and other development activities within the winter range closure time with the payment of a larger mitigation sum. We didn't focus on that, but I understood from Ms. Mitchell's presentation that they'll do everything they can to stay outside of that winter period, that their current plan includes no development within that winter period, and restates that a number of times in the application. Given that there is that stipulation in the application, I do think we as a commission and potentially staff should give a little more thought to looking back on these applications and some type of reporting system that in the event that we understand that these activities are going to take place outside of the winter closure, some kind of a reporting that if development does take place within the winter closing in this within the winter closure in this application or in any other that purports it as such, it would be good for us as a commission to understand in retrospect if those conditions were adhered to, or if actual development did take place in a winter closure period. And so, Director Larson, I would suggest maybe staff give that some thought as to how we can be made aware of that if those activities do occur.
Thank you, Commissioner. Yes, I was actually just taking a note, and we'll bring that up with our management team tomorrow, and we will report back.
Thank you so much.
I think maybe I wonder whether we could have AAG Mercer jump on screen, because I do have a question. In the way that I'm reading the 2A and the commitments from Verdad is that they have committed to avoid by not having activities within the sensitive timing for pronghorn to have oil takeaway prior to production and to have produced water takeaway prior to production. To me, those were pretty clear commitments, like they shall, not may. Is that the way that you read it, or do we need to have any further commitment to that short of the BMPs that have been proposed? My understanding is that the BMPs are binding.
Thank you, Chair Messner. That's correct that the BMPs are binding. And I think it might be helpful to get a little bit more clarification from the applicant here. My understanding is that the BMPs, and I'm trying to flip to the right one, include a commitment to avoid new operations during the winter pronghorn time, which I take to mean construction. I'm not sure, you know, in the what else that would allow to occur. I think that might be something that would be beneficial to clarify. Also, I think it was not crystal clear to me based on the language whether there is a firm commitment to hook up to produced water and oil takeaway prior to production. So I think just getting some clarification on those 2 points would be necessary.
On the avoiding the sensitive timing for the pronghorn, the timing of that is fully within all of VRDOT's control, assuming we have plenty of permits to move around, so we can drill the ones that are outside of the timing outside of that timing frame. So we feel that is all in our control, and we commit to staying out of the timing limitation. My understanding is construction, drilling, and completion are outside of the timing limitation. And so that is within our full control, and we will be remaining outside of that timing. We are planning, we are working with a third party to get the oil and water line that are dedicated to this area. We're in the process of working through it and getting that taken care of. But not all the pieces are in our control. And so we feel like we have to plan in the event that something happens with that line. Like if, for instance, we can get the oil line there, but the water line isn't there, we need to make sure we have tanks to take that water. So it's just preparing for things that are outside of our control. And that is our intention and our plan.
So Ms. Mitchell, maybe I'll ask this question a little differently, because you have proposed BMPs that are binding within the 2A in the application that says that you shall, right? You will. And so 2 questions, one's going to be for staff and one's going to be for you. You know, understanding that there are things out of your control, there are still mechanisms to be able to modify the application in case that doesn't happen, but there's got to be some certainty one way or the other, you know, in the application process, so that we understand what we're approving, which also, you know, ties into, you know, the evaluation of impacts in the transportation plan, in the cumulative impacts report, and other associated submittals that you've provided. I mean, I've read through all of those submittals, and they clearly indicate that there's going to be oil and water takeaway. And I think that your analysis incorporates that, which I think is good, right? I mean, I think that you're really doing a good job of avoiding and minimizing impacts with those analysis. And so I think I think to me, that is a very good thing. So one question is to staff: should this applicant run into some hiccup that would not allow them to tie into oil and gas takeaway, even though they committed to that in the application, what would be the potential remedy for an applicant to be able to ask for additional time or something like that, in order to be able to still be able to potentially operate prior to that tie-in?
Mr. Chair, was that a question to me or a question to staff?
Well, it could be to you or it could be to staff, but it would be a question to the COGCC. You know.
I do think staff is probably best equipped to answer. I just wanted to make sure I wasn't missing something.
Mr. Chair, apologies. We can bring Mr. Noto in and he can provide some perspective on that.
Thank you.
Okay, sorry, just working on starting my video here.
Good morning, Mr. Noto.
Hi, good morning. I'm John Noto, the OGLA supervisor. And just to make sure I understood the question, it's if there is a requirement for connecting to a line for oil and water takeaway on the Form 2A, and that cannot happen Is there a remedy that is available to the operator? If I understood that right.
That's correct, Mr. Noto.
If there's a permit condition that would be either a BMP or COA that requires that connection, then the operator would be out of compliance if they can't connect. You know, if they can't follow that permit condition, they would have to request a new condition or a new mitigation measure. It might be by submitting a sundry, Form 4 sundry, and we would have to evaluate that just to determine whether that's a significant change or not, and whether it would require more than that. So there's a process, but it's involves an administrative procedure.
May I ask a question since John's on the phone, and just to get some clarity? My understanding is if, say, we permitted one oil line and one oil tank and 3 water tanks, and something were to happen that we needed, say, 6 water tanks and 2 oil tanks or additional tanks, then we would have to go through the OGDP process again to add those tanks. Is that true? Or, I mean, if we can file a sundry to add a couple of tanks, I'm not sure of the process. So, and I've been told that we needed to do the OGDP process again. So that's why we planned for max case, so that we can come in under. So just checking into that particular process, and maybe I have something unclear there.
Thank you for the question, Ms. Mitchell. Mr. Noto?
Yeah, sure. That's the other issue that's in addition to, and is maybe associated with connecting to those takeaway lines. And it would really depend on what the change entailed. If you're going to need to increase tanks and increase the location size, and it definitely requires a new OGDP. I would think that then we'd evaluate whether it's a significant change if it didn't require an increase in the size, and given the combination of the oil and water takeaway, if that was a condition when the permit was approved, and you had a reduced tank count for that, I would think that would be considered a significant change in a new oil and gas development plan would be required. You'd have to amend your location, but not. I can't see that for certain because we'd have to evaluate, every situation, since the rules do allow us that flexibility.
Thank you, Mr. Noto. So I want to just reiterate that I'm still comfortable with this application. I think that the commitments that were made and the BMPs to have produced water and oil takeaway during production, the avoidance of the sensitive winter habitat. I mean, I think these are all things that have been clearly committed to within the application. And while I appreciate the desire to reduce tanks, I mean, I think that commitment to the oil and water takeaway during production, I mean, for this commissioner, that addresses that tank. And if they want to put more tanks in and not utilize them, then that's fine. But I think that there's an enforceable commitment to produced water and oil takeaway during production. Commissioner Cross.
Thank you, Commissioner. And I'd just like to reiterate that I also, in support of this OGDP application, as I kind of mentioned during the comments, I think that this is a little bit of a unique situation. I think that wildlife is probably the key receptor that's at issue here. And it's one of those things that can't be fully avoided. And so I think the steps that are being taken to use an existing pad, the steps that are being taken, as Commissioner Messner mentioned, to utilize additional BMPs to meet, such as the agricultural noise, to make sure that minimization is occurring with respect to those other impacts is important. And as Commissioner McGowan mentioned, I think that this has come up several times, and I anticipate the issue of using pipelines and committing to a time pipeline is probably going to come up again and again. And I kind of look at it a little bit different. First of all, I agree. I strongly prefer the use of pipelines. I think reducing the amount of truck trips is vitally important. I think reducing emissions from the tanks is also vitally important. But I also recognize that the issue when it comes to doing a pipeline, whether it be for oil connections, for produced water, for fresh water, or for gas, can be a little bit complicated, as Ms. Mitchell mentioned, because it's not fully within their control. One of the ones that we looked at previously that I think we're discussing, the operator has since purchased the midstream production company. And so I think that having the midstream production within your control is a little bit different situation. But in situations such as this, where you're kind of relying on a third party, and that's why I thought it was important to make sure to see if we were going to be using the same pathway. Because if you're using the same pathway, I think you're going to have a lot easier steps in making sure that you're getting the appropriate rights of way approvals, and that you'll be able to kind of get that under construction quicker, and using the same pipeline company as being used for the gas gathering. But it still is ultimately out of the operator's control. And I think when you look at what our rules require and saying that, are they committed to this, as Commissioner Messner mentioned? Yes, they are committed to that. And to me, that is a big step in saying we're working to avoid, minimize, and mitigate any kind of emissions impacts that we're going to have from additional truck trips. But that said, it may be something out of their control. Construction could face a hiccup, and you could have a hiccup with a single surface use agreement if you're trying to connect a pipeline to there. And so I'm hesitant to put any type of time commitments, especially where the operator doesn't have any kind of control over that situation, to say, you're only going to have to do this because and I really appreciate Mr. Noto coming on, because I think trying to say the idea of potentially this having to go back in front of the OGD process, because we had agreed to commit to, just as a date, January 21st of 2023. And then because of a construction hiccup or because of a surface use agreement hiccup, it's looking like it might be a couple weeks longer than that. Then we have to go back and potentially say, all right, well, everything else was done, but we need to go back and we need to try and get another OGD process. That's not efficient from the COGCC's perspective. I don't think that's efficient from the operator's perspective either. And so as long as the use of the tanks and the putting the tanks in the permit still fits within our rules and regulations, which I think they do, I have no problem with putting that kind of worst case scenario out there of saying, for this permit, we need to say we may need 16 tanks. And ultimately, as long as they are agreeing to hook up those oil pipelines and they are agreeing to hook up those water pipelines, I think that that's critically important to say we are committed to that avoidance and minimization that we're talking about. But there is a worst case scenario that it may be delayed slightly. And so we are going to make sure that we do that. But in the meantime, we're not going to set up for an inefficient process of potentially having to come back in front of the commission, which is for something to say, listen, this is going to take a little bit longer. We're going to need 3 tanks, even though we talked about 1. So I just thought I'd kind of point that out, that especially in situations where it's not under the control of the operator to do that hookup, I don't necessarily have that problem with not committing to a time certain, as long as they are still committing to taking those steps to avoid and minimize through the pipeline hookup.
Thank you, Commissioner Cross. Other thoughts? I would note, Commissioner Cross, that there is a timeline associated with it. It's during production that it has to be, it has to be accomplished. And so with that, Commissioner Ackerman.
Thank you, Chair Messner. I think I was going the same direction as you. Just wanted to say that I appreciate the hard work of VRDOT and their consultations that they've done. I also think this is a good application. Willing to make a motion if we are ready. Just wanted one point of clarification. Do we need to be specific in our motion with regard to Commissioner McGowan's comment about ozone attainment? Maybe that's for Councilor Mercer.
Thank you, Commissioner Ackerman. Yes, I would be recommend to be specific, just insofar as, you know, moving, should it be your desire to approve the OGDP application with the addition of the BMP
Minimize activities, certain activities on high ozone days. And there's some PAT language that staff sent to me and I gave it to Hearing Manager Larson. So now that I have it, I can give it to operators ahead of time.
Perfect. So what Commissioner McGowan said.
So Commissioner Ackerman, your motion again?
So my motion is to approve this OGDP with the stipulations as discussed by Commissioner McGowan associated with the language for ozone attainment. Is that sufficient, Councilor Mercer?
Yes, thank you, Commissioner Ackerman.
Second.
Okay, we have a motion and a second. Is there any further discussion? Seeing none, all those in favor signify by saying aye.
Aye.
Is there any opposed? That motion carries and the Gaffney OGDP is approved.
Thank you.
Thank you for being here
Thank you,
today.
Commissioners.
Commissioners, I don't see anything else on my agenda here today, except for I would entertain a motion to adjourn. Commissioner McGowan.
Sorry, Mr. Chair, could I feel like we've had a couple of questions come up about, you know, when we have operators paying the direct and indirect compensatory mitigation fee, what's happening with it? And I feel like during mission change, we adopted a rule asking CPW to give us, I think, an annual report, but I can't find the language. And so I'm wondering if I'm remembering correctly. So I'm hoping AG Davenport is on.
Or perhaps Commissioner Ackerman.
Or Commissioner Ackerman. And when that presentation might be given to the commission, I think a lot of folks are curious to know how it's going and how it's working.
I certainly will defer to Councilor Mercer if she'd like to answer, but that is correct. I think the commitment was for an annual report back to this commission on a calendar year basis. And so this is the first year that I believe CPW has begun to receive compensatory mitigation payments. And so we should expect at or near the end of the calendar year, potentially slightly thereafter, our first report from, and I believe it was a joint report with CPW and COGCC staff representation as well.
Commissioner McGowan, does that answer your question? Or
Yep. And I assume that Hearings Manager Larson is already thinking about our calendar. So thanks.
anything else for the good of the cause?
Seeing none, I'll move to adjourn.
Second.
All those in favor signify by saying aye.
Aye.
Aye. Any opposed?
Aye.
All right, thank you all for being here today.
Thank you.
Thank you.